Greetings, everyone. Welcome to New Rules, PPP and EIDL and Returning to Work. This roundtable discussion is a joint program by the Beverly Hills Bar Association and the Beverly Hills Chamber of Commerce. But before I introduce our speakers, I had a couple of reminders. First, I would like to note that here at the Beverly Hills Bar Association, we have some updated and expanded memberships. So there's a lot more to offer, and there's something here for everyone. If you have any questions or if you're interested, please contact the Bar Association. In addition, I wanted to note that we at the Beverly Hills Bar Association also has virtual office opportunities here. So if you're interested in the virtual office, or again, if you have any questions, please give the Bar Association, contact the Bar Association. You can call or contact them by email. Now, I would like to extend a warm welcome to our panelists. We have Jeffrey Bils, who is a labor and employment attorney. Hillary Johns is a trial lawyer whose practice includes employment law. Larry Johnson is a consultant and program lead advisor to the Small Business Development Center at Camino College. Stephen Hecht is a business attorney. I'm LaVonne Lawson. I'm a tax attorney, and I'm the program moderator. So contact information is in the materials. So we will be inviting Q&A through the program as well as toward the end. But if there's a question that you have that you don't get answered, please feel free to reach out. So before I turn it over with my first question, I just wanted to comment on why we scheduled this program. We scheduled this program, which is particularly aimed at small businesses, to discuss the myriad issues that they face as they open up again, and to provide an update regarding the continually changing landscape of relief programs out there for employment. So the Paycheck Protection Program Flexibility Act was signed into law June 5th of this year. It changes the calculation of loan forgiveness, it changes the repayment period, and expands the ability to defer payment of employer Social Security, and does more as well. So employers have to recalibrate. Also, there are contractual terms of the loan programs, both PPP and EIDL, that many did not take into account when signing up, with what they will need to contend. And in no small measure for employers, as they are reopening and as employees are returning, there are a number of many unanswered questions, and we have our employment law attorneys who can speak to that. So to start, Larry, I'm going to turn to you first. So I'm going to ask you, why did we need the recent Flexibility Act?
Oh, thank you very much, LaVonne. You know, I think that it was very much realized by folks based on the practical experience of businesses in trying to apply for these loans, and recognizing the reality of what their situation was, given the restrictions imposed in local jurisdictions about whether or not they could, even if they got the loans, could they employ the funds in a reasonable period of time. So that was the main reason why it was felt that this program had to be amended to make it more usable for folks in the marketplace. And that, I believe, was indeed accomplished. But today we have some very exciting, late, hot-breaking news for you, subsequent even to the creation of my slides. My first slide is not exactly accurate. EIDL applications for the emergency injury disaster loan product have been reopened. They're being accepted now. The portal is open after being closed. You can now apply for EIDL, and those EIDL funds were originally designed to be in the form of a up to $2 million loan. That cap has been lowered to about $150,000, but they are available and they're being processed very quickly and efficiently. In fact, I've heard of people who submitted their applications on the new portal at the beginning of the day today, and by early this afternoon, they had gotten a response back from the SBA that they were being approved, and to confirm their identity so that the procedure can go to the next stage.
Wow, they're getting the money out there. That's fantastic.
They're getting the money out. So, and also anyone who has been approved for a loan can be assured that that approval process is going through for the next layer. So there's several layers involved here. There's the one layer of getting the initial consideration and then acknowledging that you are whom you say you are, and then it goes to a final level of approval process, which goes through a deeper dive on your credit, and then ultimately documents would be submitted for your signature and approval of the final loan amount. Next slide, please.
I'm going to indulge in the spirit of our roundtable, maybe a little more informal than just a presentation one at a time, and ask you, Larry, as we go into talking about PPP, and now that EIDL is reopened and available, may a borrower have both?
Absolutely, you can have both, but the only restriction, Steve, is that you cannot use both for the same category of expenses. So if you're going to use PPP for your payroll, you shouldn't use your EIDL funds for payroll.
I'll check. I'm sorry.
No, Jeff, go ahead, please.
I was just going to say, I noticed a question pop up in the Q&A, which asks, I think it may be somewhat related, but I don't want to interject and interrupt you.
Go for it, Jeff.
Then I'll interrupt.
Okay.
Larry, the PPP loan window, as I think you'll explain to us, is still open. But
Yes.
Am I correct that if you have received a PPP loan, it's one to a customer? So you can't go back.
One to a business, yes, you cannot go back. Technically, EIDL is different, but the EIDL window for people who received an original amount and believe that they need additional amounts, that window has not been open for additional amounts at this point, not until they complete serving everyone who needs an initial amount of funding. Theoretically, you could get multiple EIDL amounts.
But if you have your PPP loan but never applied for an EIDL loan and you think you may need more funding, you could now apply for the EIDL loan.
Yes, in fact, I would encourage that because EIDL is more expansive. You can use EIDL for more of your working capital expenses than you can PPP. It's a much more all-encompassing program, and it is available to be used through the end of the year.
Larry, the quick question I have is so you're saying though that you can't use them for the same funds. So what if you, with the 60-40 split, what if you in the PPP funds use it for something like, say, rent? Are you saying you're precluded from doing so with EIDL?
You can, if you have rent payments that go beyond the period of consideration, you cannot use EIDL funds for the same amount of rent, right? You're using PPP for that rent. You can't use EIDL for that rent.
And Larry, when you mentioned that the EIDL loans were more expansive, they're also a little more expensive because
Yes.
they're more like traditional SBA loans where the interest rate will be 3-point-something%, the payment period a little different, and maybe a personal guarantee. Is that all true?
Well, yes, that's true. It's not as expensive as a traditional SBA. It's still cheaper than a traditional SBA loan. It's 3.75%. Traditional SBA loan would be a little more expensive than that. And also the maturity is longer. The maturity for the EIDL loan is 30 years. 30 years. So 3.75% at 30 years with a 12 months delay in your first payment. So that makes it a lot more attractive. And it can be prepaid at any time without penalty.
Now, someone has asked in the questions if you can use one loan to pay off the other loan. Is that possible?
It is possible. Some people may want to use the PPP to take care of all payroll expenses, since PPP is designed for payroll, and ultimately, if you're not approved for something in PPP, it only carries a 1% interest rate, and And under the current flexibility terms, it can have a maturity of up to 5 years.
Okay, all right.
There was
But but if, go ahead, Jeff.
Sorry, there was a question a little earlier in the Q&A, which probably has been addressed somewhat, but it was, are there any guidelines for the spending of the EIDL loan, and will there be any reporting requirements that will be required by the SBA, or will there be audits, random or flagged due to misuse, that will be implemented as oversight?
Yes, to all of those questions. You're taking government funds, so the government is very interested in what you do with those funds. And the government never forgets. So you do have, you're at risk of being audited. So you must keep very good, clear records. I would recommend having separate accounts, having a paper trail, actual paper and or digital trail of where the funds went after you received them, how they were allocated. If you're a sole proprietor, sole practitioner, solopreneur, if you receive PPP funds and you're going to pay yourself a salary, then do that in a fairly formal way. Make either a transfer to another account, that's a personal account, or write yourself an actual check from your business account to your personal account, to yourself as a person, so that you can prove that there was a payment made from the business for salary purposes.
Larry, I hope I didn't get this wrong, but when the PPP money came out, one of my clients called and asked me, should I put it in a separate account? And I said, absolutely, that's a good way to keep track of it. And I think you're confirming that was right.
Yes.
But what about the situations where separate accounts couldn't be open, either because a bank didn't want to bother with it, or a payroll company decided that it's going to be too difficult to have a short-term payroll account, and then you go back into your regular payroll account?
You just need to make sure you've got adequate records that can document that certain amounts went for certain purposes, and you can show the trail.
Now, a question that someone had asked, I think someone had asked if you could use PPP funds to pay off EIDL, but you could do it the other way, but I imagine you can't use, because of the strict limitations of what you can use for PPP.
Right, PPP can only be used for salary, rent, commercial mortgage payments, or loan payments for assets like equipment loans, that type of thing.
But you think for EIDL though, you'd have more flexibility, as I think.
You have more flexibility because you can use EIDL to pay for. You can hire 1099 employees and use EIDL funds to pay for.
And Larry, don't we have two more categories for PPP that are actually difficult ones? One is transportation and the other is utilities, and a lot of debate over utilities.
Yes. What are utilities? There's some definition in the documentation that defines what actual utilities count: electric bills, gas and water, and that sort of thing. Cable bills.
I had a question, Larry. I think for a lot of us, I mean, there's so much information about it, and you're obviously really far more knowledgeable than most of us are. If you were a person or a small business owner or a lawyer that wanted to learn more, what resources do you think that are available online I'm sure there's a lot of them, give particularly good guidance? For example, someone looks at this program today and thinks, this is really helpful. I got a good overview. I'd like to read more about it. What would you recommend, Larry?
Well, a couple things. It's difficult to recommend a specific static source because things change constantly. And so if I had to recommend a source, I would say go straight to the source, sba.gov or to the U.S. Treasury website. There you will find the actual documentation. Now, it will be in legalistic terminology, but I don't think it will be difficult to parse the meaning. And you'll get the latest information on those two websites without any editorial comment. what's going on. And so I would always go there. There are lots of other folks. The U.S. Chamber of Commerce does a great job of putting out information, and many of our fine law firms and accounting firms, even the regional firms, do a great job of synthesizing the information. But again, it's only as accurate as the latest information that's been sent out by the federal government. And again, that can change on a moment's notice. At the end of a day, at 5 o'clock in the afternoon, we're sitting in our offices about ready to pack up, and along comes this notification of clarification or additional announcement, or there's a press conference in Washington, D.C., and Steve Mnuchin gets on, Treasury Secretary, and makes an announcement about the EIDL program that you weren't expecting, and suddenly
Right.
it's news, and it didn't come out originally as a release from the SBA. So we've got to be ever vigilant, and I would go to the government's resources as the Bible, so to speak.
Well, you know, when they changed with respect to the Flexibility Act, when they changed the repayment periods and they changed the percentages, what problems were they trying to fix?
Well, I mean, the basic problem is that let's say for restaurants, for example, you have a restaurant, you're in Southern California, and you've got 2 months within which to use this money. That's just not legally possible for you. You can't do it, and the federal government wants you to do one thing, and the state and local government said, nope, you can't do that. So are you going to not use? A lot of people said, I'm not even applying. I can't use this. It's not going to work for me.
Got it.
And so that's what they were going after, the reality of the situation. I can understand they wanted to encourage people to bring people back. The spirit, the idea, the concept was laudable, but in the reality of life got in the way.
Got it. So was there anything, for instance, also I noticed that the repayment periods, you don't have to, so first of all, there's only repayment if you don't get the forgiveness. But if you don't get forgiveness, then now you can start, it looks like, what, 10 months after? That's a dramatic shift now.
So the repayment eligibility is a major issue here, and they haven't clarified the details for eligibility given the new program. The new program says that you've got until the end of the year to use the funds.
Okay.
And so what does that mean in terms of forgiveness? So we don't exactly know how that's going to be applied. So we're awaiting the official guidelines for forgiveness, and so we can't answer that in detail. But there will be a process that will allow you, if you use 60% of the funds, at least for salary, with the balance being used for other approved expenses like rent and utilities, you should be forgiven. There were very specific guidelines in the old program. You had to really make sure you had certain full-time equivalent employees. We're not sure that that's going to survive given the new rules and given their definition of safe harbor for certain employees. For example, if you had an employee that did not want to come back because they felt unsafe, or an employee who decided that they didn't want to come back at all, you wouldn't be penalized for that.
Okay, so more flexibility, but you have to establish it, and there's not really guidance there, is there?
Well, you had to have offered that employee the job in writing.
Okay, so
and the other thing that was really important, they said if for government requirements you could not bring back people to your place of business, you wouldn't be penalized. Okay. So the full-time equivalent, you had a safe harbor for that. If there was a requirement for, let's say you had a restaurant, you could only staff half of that restaurant, then you were prohibited from bringing everybody back. So you had a safe harbor there. So the calculation then, so the forgiveness is going to have to be changed. There's a lot of pressure that's being exerted on Congress to really be extremely flexible on this whole forgiveness formulation. So we haven't heard the end of that yet.
And then also the banks, if there is not forgiveness, are they penalized in any way?
Are the banks? I'm not sure I understand the question.
Because I thought I read if the banks get a fee, but they don't get a fee if the loan is not forgiven. I must have that incorrect then.
Yeah, I don't think that that's the case.
Okay. So
The banks are not responsible for forgiveness. The bank, in terms of the documentation, right? The banks have to process.
and they make a determination, don't they?
And they make a determination, but the content of what's being presented is the borrower's responsibility. And I know Steve is going to get into that because there are lots of important legal implications to these agreements that we're signing for the EIDL agreement itself, the PPP agreement, and the assumptions associated with those agreements and the signatures that we put on those.
Well, speaking of that, Steve, Steve, what are, because I know that you and Larry both kind of have conflicts with respect to what people are getting into when they participate in these programs. But Steve, I also wanted to ask you about some of the, the repayment periods and all of that you see under the new act.
I think repayment periods, it is a little confusing. We have the 2-year loans.
Okay.
Larry's going to correct me immediately. We do have 2-year loans, and they're due in 2 years. And you have a relationship with your lender and loan documents with your lender. And that promissory note is going to have will have those requirements in it. Now, we have the issue of forgiveness. If you were able to obtain forgiveness, you don't have to repay the loan. So how do they interact? Well, you can wait up until 10 months to make your application, 10 months into your 24-month period to make your application for forgiveness. Now the SBA has 6 months to determine whether you get forgiveness or not. So now the SBA says, no, you don't get full forgiveness. Now you have a loan that you have to repay. You get some forgiveness, maybe you don't get full forgiveness. Now you have a loan on the books that you have to pay, and it begins in month 17. So you've gotten the joy of not having to pay anything for 17 months. And now you have to pay everything back between month 17 and month 24. That is beginning of repayment on forgiveness. Overlay to that is in the Flexibility Act, we now have 5-year periods for new loans. Pressure building, as Larry said, can apply the 5 years to the old loans. But right now, they don't apply, and it's a matter of going to your lender and saying, please, could you give me 5 years to pay back? Your lender says, give me a break. I'm making 1% on this loan. So, no, pay it back. I want to make a little money. And you have a pre-existing relationship with your lender. You have lines of credit with them. Maybe you get a break. Maybe you don't. That's where I see it right now. But more to come, as Larry told us.
So there are a lot of unknowns still with respect to how this is all going to pan out.
Absolutely. In flux.
Okay. Well then,
But there are rules now, but probably may change.
okay. Well then we'll see. And do you see more, pending? There's other pending legislation that I anticipate that you see, Stephen, or.
I do, and I should apologize to everyone. I'm the keeper of the slides. I've been trying to keep them in order, but in the spirit of our roundtable, we're jumping
No
around.
worries.
And I chose not to jump around on the slides because that would have induced some kind of grave pain into everyone. There's more legislation coming, and I'm going to cheat a little bit and jump ahead to my slide on more legislation, and we'll take a quick look at that. So the CARES Act itself has $130 billion left to lend under PPP programs, so that's pretty good. Now, the House went and passed a $3 trillion additional CARES Act funding mechanism in the HEROES Act, which, if you remember, and led to a great deal of opposition from the Republicans on the grounds that this was nothing more than a way to put in all kinds of programs that Democrats have wanted for years but have never passed. So we're waiting on the Senate to act on the HEROES Act. How long? My answer is probably forever. Will not act on the HEROES Act. So what will it act on? Right now, either what we can call the fourth round under the CARES Act, or perhaps a brand new bill. And it looks like a brand new bill is on the way sometime in the next few months. Dollar amounts talked about, maybe $1 trillion, and it may be targeted at infrastructure. As you know, we've been waiting 3.5 years for the infrastructure bill to appear. It never has. This may finally be it, or it may just go into help and relief for businesses. We don't know. Quick comment on two other things that are going to happen. The Truth Act. What's the Truth Act? Well, this again would require the disclosure in the name of transparency of all borrowers who've received loans. That was introduced in the House. It hasn't passed yet. Very unlikely it would pass in the Senate. There's a lot of objection to it in the Republican Senate, but nevertheless, something may be worked out. And finally, we can anticipate administrative action rather than legislative action on the forms, because now that we have the 60-40 rather than the 75-25, we have the 24-week, not the 8-week, and different kinds of calculations. What came out before, which was in the way of a 4-part application that had a loan forgiveness calculation form, a separate Schedule A, a worksheet, and then some voluntary borrower demographic information. But the 3 were required. They were all geared at the old 75-25. They may still be good, just with percentages changed and new forms will come out. On the other hand, recently there's been a lot of complaints in the Senate particularly, and perhaps good for the borrowers, that too many lawyers and accountants and business consultants were being needed to figure out what to do and how to get forgiveness. So there's talk of a much simplified form coming out that's going to have check the boxes on it. Did you do this? Did you do that? Yes, yes, and you check the box. Now, before we jump with joy to take advantage of checking our boxes, I included the certification that actually is going to go on here. As Larry mentioned before, it's a certification by the borrower, but it needs to be checked by the lender. And here the borrower is telling us, yes, it's all true and correct in all material respects, a word that always jumps out to lawyers, what's material. And if you fail, you get fined. The government neither forgets nor, I think, will the government not be anxious to start to go after people, because we are going to find, as we already have, abusive behavior has gone on. And a lot of people have taken these loans, didn't need it, didn't have companies, didn't have employees, bought Ferraris or Lamborghinis, and so difficulty is on the way. And the certification that we've talked about needn't be signed by an officer of the company or by a managing member of a limited liability company, or even by a partner in a partnership. It can be signed by someone called an authorized representative. Well, the one word I have for the lawyers, accountants, business consultants, and anyone else who's watching, excuse me, I choke on the thought. Don't be a pal. Do not sign this form for anyone else. You should never, ever be an authorized representative. And if at any moment during the day or night, 24 hours a day, you have the urge to do it, my email is on my
Well, I'm going to throw it out.
I'm going to talk you down no matter what time.
I'm going to throw it out to all of you then, because these are, so you're looking at potential places for problems. Well, a question I have for you, Steve, and for anyone else's thought is that, okay, but there is in other words, who's going to be reviewing these smaller loans? So, I mean, is it really, I mean, what are the different ways that, one could end up kind of on the wrong side of this by being a pal? Or is it just, is it just that it's just a good idea generally, or are you anticipating that there'll be opportunities for review of these loans?
I understand that knowingly making a false statement to obtain forgiveness may be punishable by 5 years in prison and a fine up to $200,000.
Right. Okay, that's true. That alone is enough to
Yeah.
talk most people off the cliff. You're absolutely
And there could be False Claim Act
Yeah.
claims.
okay.
I think what Stephen is saying is that we all know that that is going to happen. I mean, unfortunately, there are just people who take advantage and people really need. And speaking of need, there are 2 Q&As here that I think Stephen and Larry would both be very able to answer. And I think all of us could benefit from one of them. They already talked about the PP loan forgiveness. What category do health insurance, would both of you think, fall into for expenses? Would it be EIDL? Would that be a PPP loan? What do you think about that?
So health expenses, if they are related to the employee, right, are included as part of the payroll expense as far as PPP is concerned.
And then I think.
But there's another part to.
Okay.
So
Good. Yeah. No, I don't know.
So, an independent practitioner, and you're looking to calculate your applicable salary for PPP. Your personal health insurance is not expense is not included. It's really part of the group health insurance coverage for your employees. If you have W-2 employees, that's part of that calculation.
And there was another question here. There were some comments about EIDL. Just wanted to some clarification about whether EIDL funds can be used for additional payroll expenses for W-2 employees beyond what a PPP funds will cover. And if you can't do that, why not?
Yeah. So the issue is you don't want to double up, a double dip. You don't want to pay for certain expenses with PPP and also pay for the same expenses with EIDL. That's not allowed. But let's say I think the example that was in the question was, if I utilized PPP to the fullest extent, but because my business is an ongoing business and I have idle funds remaining, can I not use idle funds for those new payroll expenses? Well, because they are new payroll expenses, then you should be able to use those idle funds for those expenses, but not for the same identical funds that you use initially for PPP.
So if you ran out of PPP, could the EIDL, in a sense, step in for those expenses? Would that be allowed?
That would be eligible expenses. They're not the same.
Okay.
And then I guess you need to have some good record keeping in terms of how you use it.
And everyone will run out of PPP because it's only there for a relative small number of weeks in the universe of time that businesses hope to be open. So yes, one's going to run out and you need new capital sources.
Okay, so, and let me ask, with a payback, to say to decide for whatever reason they want to start paying back, I'm assuming the PPP cannot be used to pay off the EIDL, but vice versa, would that be acceptable? I don't know.
You can't use EIDL to pay off obligations.
Can or cannot?
Cannot.
Okay, but can you do it the other way?
Well, you can use PPP to pay off your EIDL that you were going to use for salary. If you got the cash, emergency cash advance, and you wanted to, and so you use that for payroll, you could pay that off with your EIDL, with your PPP funds. You can refinance certain parts of EIDL into PPP. Yes, you can do that.
Okay, but again, as LaVonne said, I think you'd have to have really, really good record keeping.
Yeah.
Sure, this is, and as Stephen is cautioning everybody, and I think wisely so. I did have one other question here. If one wants to start paying back sooner rather than later, how do they go about that?
Talk to your bank.
Yeah, because
And there's
how
debate.
long, you have to wait longer to determine if you can get forgiveness? I mean,
Yeah, the rules are in place. The specific rules, the spirit of forgiveness is there, but we don't know how to apply it yet because there's so many questions now that the Flexibility Act is in place.
But if
okay.
we look at Larry's slide on funding considerations, which is up now, I think we see that originally it was an eight-week period for the calculation, and then there could be an application made when they finally appeared, which they now have, although they'll be changed because of the difference between the 60-40 and the 75-25. You can make early application for forgiveness if you choose
Right.
to do that, or sooner application for forgiveness. There may be good reason not to do it, but it's certainly available to you. And now that we have the 24-week period, it may simply be a little bit longer because you need the 24-week period to meet your 60% requirement. A question I was asked is it still an 8-week measuring period, but embedded in a 24-week period? Or do you measure whether you meet the 60-40 test over a 24-week period, not 8 weeks within the 24 weeks? And I believe the answer is you have the full 24 weeks to make that happen. And that, unless Larry has a different thought, that's what I...
No, there's a lot of uncertainty and ambiguity around that point. And,
Okay.
So I can't dispute what you've said, only that I've heard in all the calls that I've been in with the SBA folks is that there will be clarification coming down with regards to that.
Before I ask, like, what other things that one needs to be concerned about if they now have signed up for all of this and have to operate within a certain structure? Let's say you want to start paying off EIDL early, would you just contact the SBA?
Yeah, contact your SBA loan officer.
Okay.
The government has never turned down money.
Yeah. Okay. Fair enough. Fair enough.
So I
So,
have a question. It may be for Jeff or Hillary to pipe in too and help. And assume a business, and I think for those of us who are here from the Chamber of Commerce, this may be a particularly business-oriented thought and question I have. You meet the test, you qualify. You find that you have spent no less than 60% on your payroll. So now you are entitled to full forgiveness. And you do that either in the existing 8-week period or in the first 10 weeks of your 24-week period. So now you have 14 weeks left in that 24-week period. Do you need to wait for the 24 weeks to run out? Or if you do need to make staff reductions, can you start laying off people and not harm the calculation of your full-time equivalents that you needed to meet in order to get your 60% of payroll spent on the right amount of people at the right amount during the right period? Was that too jumbled?
no.
I
think the question makes sense. I just don't know if anyone.
If you follow the rules and you've done it all, on the next day after you follow the rules, can you reduce your staff if you need to?
Yeah, I think the question makes sense. I don't know that it's an employment law question necessarily. I
don't think it is.
Yeah.
I need help.
I think when the game is over, you can do anything you want to do. You know, I mean, you've met the obligations of the program, and so technically the program is over. There's no more measurement.
Interesting.
And so if conditions suggest that you can no longer economically maintain the staff that you had to maintain up until the end of the measurement period, then you've got to do what is feasible economically.
Well, for Jeff and Hillary, I mean, are you getting constant, communications with people regarding staff? I mean, what are the staff issues that you're seeing out there?
Jeff and I talked about this yesterday, emailed about it yesterday and talked about this afternoon. Jeff, do you want to speak to that first?
Well, in terms of the staffing issues, if you are going to be laying people off, there's a lot of things that you need to bear in mind. I don't know if this is directly answering your question, LaVonne, but for example, the WARN Act requirements that were subject to one of the orders that came out early from the state of California, you still have to give a WARN Act notice. The length of time within which to do it has been changed, but the obligation is still there. Things like that you just have to be aware of. COVID-19 doesn't make all of these other requirements go away when it comes to laying off or furloughing employees or whatever you need to do economically. And I think a lot of times what happens is we may get so focused on, okay, what do we do now to deal with this crisis, that we lose sight of the potential liability that might come up if we forget about other things that we ordinarily would do.
Got it.
And I think Jeff and I had also talked about that, and to us, Jeff and I, it seems fundamental because we deal with this every day, but for some people it may not, that all other rules, ADA compliance, hostile work environment, sexual harassment, work and overtime wages, you need to be doing this, or you could be subject to other applicable fines. This is a very fast-growing area where people aren't getting paid timely, people aren't getting paid overtime breaks. Again, Jeff and I talked about defamation and use of social media. This is particularly true in monitoring your workplace, having those agreements in place, making sure that you're in compliance with state rules. I mean, some people may not know, if you have employees working remotely, there is a poster you're supposed to send to them. I mean, if you have employees over a certain amount and things like that, people may, I mean, Jeff and I are beginning because we do that every day.
How do you possibly monitor breaks and things like that if people are working remotely?
I have them report and let me, I mean, for example, in our firm, we have a list of when did you take your break, and if they're not doing it, they need to be spoken to right away and say, look, we can't have you doing this if you're not going to be responsible enough to take your own break. I mean, you would hope anybody over the age of 18 knows how to take a break and knows how to do that, but sadly that does not always happen, and you have to be sort of more on top of it. I mean, I know several, my office does, we are fortunate, we have people who are good about that, but I have talked to other businesses and they're like, we bother them once a week. We've advised them during COVID if they're working remotely, checking in with them to say, okay, we're not auditing them. I mean, when did you take your break and what time? But if we get the sense that they are missing one of these, then we make clear, look, you need to do something now. I have like 3 questions that just came up here real quickly.
Okay.
I think we be off subject, and we've probably, with all the interesting information we have, real quick, can you include 1099 expenses, independent contractors as payroll expense? Is that
No.
Nope.
No.
It says the promissory note we signed for EIDL limited the use of it to capital. Why couldn't we use the EIDL to pay other higher rate business loans that exist?
There are restrictions on what you can use EIDL funds for. They're not to be used for refinancing of business loans, but you can pay the interest on business loan debt, but not repay an actual loan itself.
So the interest, but not the principal.
Right.
Okay, we've got a pretty long one here. Well, actually, we have one before that for self-employed contractor who received PPP. What documentation the lender or SBA will require in place of payroll documents for proof of the 60% payroll?
Well, if the self-employed contractor has only him or herself, then we would assume that that contractor is putting that money into his or her business bank account and will issue a check or a traceable, trackable transfer to his or her personal account. That is the proof of those funds being used as payroll.
Now, Go ahead. I'm sorry, Hillary. Go ahead.
No, go ahead. I think you answered the
Just that I definitely want to make sure that we also kind of touch upon kind of some of the war stories that Hillary and Jeff are seeing out there, because as people are coming back to, getting back to work and opening up their employment areas or places, there's a lot of concern about how to do it safely and properly without getting into trouble. But I also wanted to follow up a little bit. Steve, you had noticed in your outline, there were some other things that you noted that people will have to comply with as long as they're kind of have these loans as well, what they've signed up for. Weren't there also terms with respect to, not changing the nature of the business, not selling, things like that? Are there other things that if someone, is signed up for these loans that they'll have to live with? Either Steve or Larry or whoever else has any comment on that.
I would say there are many things they have to live with. Of course, if you're forgiven, fine. If you're not, you have underlying loan documents, and they include your promissory note, your basic business loan agreement, your disbursement request, a corporate resolution to borrow the money, and a borrower's certification. These were all bank-generated SBA-required documents. In the happiness and joy and need of getting that money early on, people signed them, they didn't read them. I had nothing to do, so I read one set of them. And they're similar. For example, if you have a line of credit with a bank, you've probably gone through the same process. But within those are all types of obligations that you have. You've made representation and warranties as to the truth of things. You have all kinds of covenants, affirmative covenants where you're required to do something, and negative covenants where you can't do something. One of the things you cannot do is change the ownership structure of the borrower. So let's think about that for a moment. I'm not sure yet what that means, but if you need to raise capital, as I anticipate many businesses will need to do, where are you going for that capital? So the government programs are going to end. You'll be back into the marketplace with all kinds of products probably being offered. One of them, maybe just at the end of things, you have to sell your business. You can't keep it going anymore. And there's going to be a lot of people with money out there looking for bargains to buy businesses. But you may have to do it. And now you've got that original loan and what's required in that loan. Now the lender may be thrilled to let you go ahead and do it, but I'm just pointing out to you that embedded in all these documents are all types of requirements. Go back to the certification for a minute. You said in that certification that you were current on all of your child support. You own 50% or more of the business or a voting interest in the business. Now that's a little thing, nobody thought about it, but people are going to get nailed on this because, as we've all agreed, the government doesn't forget. The government's going to start looking. The government's already taken criminal action in half a dozen cases. The government takes years to bring criminal cases. They did this in weeks because they're hopefully not going to let this get away from them. The optics look terrible, and the actual behavior is equally terrible. So just on the point you made, and I'll conclude everything I have to say today with one little comment left on Jeff and Hillary and what they need to tell me before we sign off today, or at least get me on the right track. But on my sort of world, your loan's forgiven. That's better than anything. But it's not going to be forgotten for you because, as we pointed out, audit possibilities continue. People can come and take a look. Yes, of course, it got forgiven. It doesn't mean it was accurately or properly forgiven. You're going to have all kinds of due diligence obligations coming in the future. Just the traditional ones that arise, again, when you do a funding transaction or you seek perhaps to sell a portion of your business or whatever. Well, when those lawyers come in to do the due diligence and check things out, believe me, they'll all be focused on what happened during this period of life. It could be 10 years from now and they're back looking at the books and they want to know, did you do properly with your with your PPP loans and your EIDL loans. It may not be 10 years, but it's going to continue. So it just leads me to think this is a really good opportunity to get things straightened out within the companies that you're working with. We talked a minute ago about a corporate resolution. I would almost bet that no one actually did the corporate resolution. They certified to the fact they had a corporate resolution. That's not the same as the actual resolution. And if during due diligence in a transaction or a government audit, they come in looking and they find out the president was never elected president, ever. The company got formed, you did it on LegalZoom, it's all, registered, you pay your taxes every year, but you don't really have a properly organized company. So I would be alert to that. Now, what do I worry about in terms of reopening, which we were going to talk a little bit about today? Well, the first thing, as I've said, I have great admiration and sympathy for my employment law colleagues because this field is terrible from a business lawyer's perspective. When I go to find out what in the world I'm dealing with, I've got federal government rules and regulations, and now I've got them on two sides of it, the traditional labor side of it, and now I got sort of the health COVID-19 disease side of it. So I've got agencies sending out different kind of missives on both those sides. And then from the federal, I got the state, same two things. I might have a county and I got the city. So I got 4 sources, 2 within, that's 8 possibilities, and I once counted up to 11. I don't know where I got the other 3. So I know as a business lawyer, and this is about all I know, that I have 2 absolute requirements. One, I have to provide a safe workplace. Whatever that might mean, I have to do that. And I have to provide reasonable accommodation to people who need reasonable accommodations. That's without regard to COVID-19 disease. Now overlaying it all is COVID-19 disease. So the question is, what in the world do we do to reopen? What is our best practice? And my mini case study is an amalgam of multiple clients that I've spoken with. Stephen, they say, we know there's a lot to do, but the truth is we don't know what to do. It changes all the time. We read, we hear from different people. Our business lawyer tells us one thing, maybe our employment or labor lawyer tells us another thing, and we don't know what to do. So we're just going to be careful. We have distancing in our light manufacturing facility, 6 feet apart for sure. Everyone has to wear a mask. We have sanitizer everywhere. You take the I asked, you take the temperatures when the people, no, we don't bother to take temperatures. First of all, 2-day incubation period anyway with a temperature. So yes, we might be able to weed out people who already have the disease, but no, we don't do it. And 2, why would we? The bus stops half a mile away. People are getting off the bus. They run here like hell to clock in on time. Well, their temperature is going to be all over the place. My point is, clients really don't know what to do. What should they do? And as someone said earlier, where do they go to find out what they should do?
One important question on here that I think an attorney has to answer, and it's regarding PPP loan forgiveness for rent paid by the PPP borrower if its landlord, pursuant to a pre-existing written lease, is of a different corporation from the borrower, but both corporations are owned by the same individual. In other words, you have the left hand paying the right hand,
Right.
having its own tax ID.
So it does harken back to a question before about what sources do people look at in the PPP EIDL area. And of course, we have a statute. We've had no case interpretations yet, no lawsuits or decisions issued. So where do we look? Well, we really have 2 places to look. One, our press releases come out. I set that aside for a moment. But the 2 key places to look, this is a way of saying, I think the answer is yes, you're permitted to make a related party rent transaction if you have a pre-existing lease. However, the 2 places to look are either in your frequently asked questions or in your IFRs. And those interim final rules or in the FAQs, I believe covered that, and I apologize to the person asking the question. I've read a lot of them. I don't remember the specific answer to that one, but maybe Larry does. Larry?
I don't remember the answer to that one, but I thought that would tickle your knowledge.
Worse than that, I think I did know the answer and I'm not recalling it. That's even worse.
But the wonderful thing is that there is a place to find it.
There is a place to find it, and I'm 99% sure, more than 60%, more than 75%.
Good odds.
Yeah, so
100% sure it's either in the FAQs or the IFRs that came out at one point.
yeah, and you'll find those on SBA.gov or on the Treasury website with regards to these programs, and they are a comprehensive list of the frequently asked questions and
There was one other question here. Where would we find the restrictions on EIDL use? Larry, I know we talked about some resources. Would the SBA.gov be one of those?
Yeah, that would be the restrictions would be there. It's all defined in the use of it's for essentially for business operating expenses. Someone had a question with regards to whether or not you could pay principals health insurance costs with PPP. No, you can't. And you can't really pay that with EIDL because EIDL is for operating expenses of the business. Now, what you can do, you can pay the principals can set themselves up to receive a salary, and then they can do whatever they want to do with their salary. But they're set up to pay operating expenses of the business, which includes salary and working capital expenses, repair of equipment, but not purchases of new substantial equipment.
I want to make a quick comment, just a minor comment regarding the tax, and then I'm going to turn again to some employment issues. Simply that there was I mentioned early on, there was a little bit more of a gimme, and then there was something else that we didn't get. So one thing is that under the CARES Act had provided for a deferral of employer-side Social Security. Those payments could then to be over a particular time from the end of March through December, those payments to be paid by the end of 2021 or 2022. But then once someone got a notice of forgiveness, then they no longer could get the deferral. But under the Flexibility Act, the forgiveness as of June 5th does not preclude deferral for payments, after June 5th. But something for people to keep in mind for anyone who wasn't aware, the forgiveness is, while forgiveness itself is not considered cancellation of business income, the related expenses, at least at the federal level, the related expenses are not deductible if there was forgiveness. On the state, California state, it's different. The forgiveness would be included in income, but they could get their expenses. So we got there, the Flexibility Act provided some things, but did not kind of provide, a lot more relief in other ways. And so I just wanted to throw that in there. But employment, I know there's a ton of employer issues, and I'm not hearing so much from Jeff and Hillary as I know I heard from you all previously. So, if I've got a business out there and I'm about to get started again, and I've done everything that I think I can, I have a ton of gloves and a ton of masks and a ton of sprays. But still, what should people be thinking about that they're not thinking about?
Well, I would say one thing to think about, and this also goes to Stephen's question, is wage and hour issues that are going to come up, especially as we begin to reopen, and if we have employees who are continuing to work remotely. The California Labor Code provides that employees can seek reimbursement for their reasonable business expenses under Labor Code Section 2802. So this is something that sometimes, especially smaller businesses, smaller employers don't know about. If you have an employee working remotely via computer, using their office, using their telephone, that individual is likely entitled under the California Labor Code to reimbursement of these reasonable business expenses. It depends on your situation. And that's just one of many labor, sort of wage and hour issues that can come up, including, for example, if you have exempt employees who are subject to one of the exemptions, a professional exempt or executive exempt employee, and all of a sudden you have adjusted their compensation so that it falls below the threshold necessary for the salary requirement. Or alternatively, you have that person doing a lot of job duties that previously had been done by non-exempt hourly employees, then all of a sudden their duties test might not meet the exemption. And it's easy to lose sight of these things as we try to be flexible, but if you don't do it right, you can be faced with a business can be potentially faced with a very expensive wage and hour class action or a private attorney's general act action. If you don't provide some of the break periods or rest periods, if you don't provide some of the paid sick leave, any one of these things can potentially give rise to a representative type of action or a class action like that. I'm sure Hillary and I talked about some of this, and there are other things too that I think are easy to overlook.
Yeah, since we're coming up in the hour, Jeff, do you want to tell everybody? I know we'd sort of divvied up some of the subjects here. Jeff, do you want to? I know you were going to speak about how does sick leave apply now that people are going back to work. There's this COVID thing. What happens there?
Yeah. So California always for quite a few years now has had paid sick leave by state law, and of course all of the a lot of local municipalities, including Los Angeles, San Francisco, Santa Monica, so on, have their own local paid sick leave laws, and those are still in effect. So during the COVID-19 epidemic, there was a lot of discussion about the paid sick leave that was provided under the FFCRA, the federal law, and that exists for specific purposes. So the question might come up, okay, I have an employee now who's asking for paid sick leave, but I don't think they fit within one of these FFCRA emergency paid sick leave categories. What do I do? The answer is, don't forget about the other requirements that are still in effect. The California paid sick leave law, and if it's applicable in your jurisdiction, a local city ordinance related to paid sick leave. A lot of times, as Hillary mentioned when we were discussing, a lot of times the most efficient and most conservative approach is to understand the jurisdiction you're in, identify the most generous paid sick leave that's available, and just use that as a guidepost to avoid potential litigation exposure.
Those will be situations, for example, if you're working remotely and say your office is in Beverly Hills, but someone's in a city that the minimum wage is higher, or they have different sick leave requirements. Like, for example, Oakland, I know, is one of them, and a couple of Bay Area cities I know they have in LA that have sick leave pay, or they're raising rates for minimum wage. That's always the question. If someone works remotely or commutes or travels, like Jeff and I were talking about an example where people are in two different cities during a day. Okay, they've worked in both cities. What's at least the minimum wage they have to pay? What is the minimum standard you have to meet? And one may be doable, one may be harder. And I think Jeff and I both agreed for situations like, particularly if they're working remotely, because wherever they live, that's where they're working. That might be, you pay them the higher wage, whatever city says higher, whichever is more generous and more in favor of the employee. I think, Jeff, would you agree, to be in compliance or have a better chance of being in compliance, you need to follow that rule?
Yeah, as we discussed, anyone can sue for anything, but if a company is interested in mitigating against its risk of liability exposure, it's going to be cheaper to pay the higher minimum wage or whatever it might be than to try to defend against some wage and hour action down the road.
And it's I think we also talked about, Jeff, what do we do in situations? I know a lot of people want to know, what if someone comes in sick to work? I don't want to be around this person. They're coughing, they're sneezing, this does not look good. Or you have the other situation where a person's like, I'm not coming into work. I am not putting my life in. I don't want to quit, but I need you to let me do something else. We don't want to get a wrongful termination suit because you can't get these. Well, Jeff, what do you recommend? I mean, what's the advice you would give to a business owner, like one of Stephen's clients or one of LaVonne's clients, saying, they've got this guy in here, they don't want to come in, but I can't I'm not going to fire, if I fire them, am I going to get sued? Or you have the other one where someone's sneezing or sniffling and you're going, ugh, I don't know if I want them in the office at all.
Yeah, well, it's a really good question, and it's going to be a balancing act. However, a starting point is going to be the Injury and Illness Prevention Plan, the IIPP, that hopefully all employers have in place under the Cal OSHA guidelines that came out during this pandemic. Cal OSHA said, employers, you really have to revise your IIPPs. It's sort of what you do if there's an injury or illness that's in the workplace. So you can start with that. And then if someone is ill, you have an obligation as an employer to make sure that you don't put other employees at risk. If you have an IIPP in place and you have other policies in place, for example, employers can do testing for COVID-19, screening tests ahead of time. There's some balancing that needs to be done there, and I think Hillary might want to talk about this as well with regard to privacy, but there's guidance available. The bottom line is that if an employee calls in and says, I'm not comfortable coming into work, let them exhaust their paid sick leave under the California and local ordinances as a starting point. And then work on an individual basis to make sure that they're safe, coworkers are safe, and follow your policies. Do what you ordinarily would do, but in addition, don't lose sight of what you have to do in any event, but also make sure that you're keeping your workplace safe and the employees healthy.
Right, and I think Jeff and I also talked about there are other claims here. If you have a staff of, say, 15 people, and someone is coming in and they're ill, and we have this happen, the person goes, look, I got to work. I can't afford to stay home. I can't take it anymore. I can't afford not to earn any money. I'm really worried. And the sick pay, sometimes the sick pay and the other benefits actually wind up being more than the person's being paid, but other times like, look, I got a mortgage, I got kids, whatever it is people are going to work when they're sick. They are, we're seeing that. You can, I know Jeff and I touched upon this, you can't get sued for a hostile work environment. If you have a situation where someone's coming in, they're sick, and there's a problem, and you don't do something, these other people are like, you put my life at risk. I mean, you've got also the workman's comp presumption there, but they're going to assume if you get COVID-19, it's a presumption it happened in the workplace, that can kick in. It can lead to a whole myriad of problems. So you almost have to be more diligent about it. And I know, because I know we've been over an hour, and I know there are questions afterwards, and we're probably going to hang around and answer them, but just in case people want to get going, one, can I get sued? Yes, you can always get sued. People come to Jeff and I all the time, and I'm sure to Stephen and to LaVonne saying, if I do all this, will I not get sued? Yes, you can still get sued. Anybody can sue anybody on any given day. It's true, they can, and it's California, it's litigation city. They're more likely to do it here.
Hillary, I'm going to jump in just for 1 second to let Larry go.
Okay,
Because
Larry.
has to go. So we want to say thank you, Larry, but then Hillary, I want you to go ahead and finish your point, and then I had to connect the question to Steve.
Thank you very much, everyone.
Larry, you were super. Thank you.
Larry, you were awesome. Thank you so much.
Larry, thank you. It's sorry, I'm being photobombed by one of my pets. So Steve, we're living in the golden age of pets. I know Stephen has his cat too. So they often we talked about, Jeff and I were talking today, and there's a couple of things that I think Jeff and I both thought, three or four things, well, there's a lot, but anyways, ADA compliance and working remotely. If a person for example, they can't wear a mask for medical reasons, insurance, how that works, and what are the penalties that we're going to be facing for non-compliance? And is that going to put our loans in jeopardy, our business in jeopardy? Jeff, I sent Jeff an article last night, and he probably would have seen it anyway, but it was that businesses are reopening, more than half, like in restaurants, were not in compliance with social distancing. I'm getting feedback from business openings saying no one's social distancing. There's no masks. I don't see any, I don't see a sanitizer in sight. These are real, not business and employment, and that I think it'll affect people at the federal level, state and federal level, if they're getting funding. I really do. I think eventually, I don't think there is any way to enforce this. Jeff, you mentioned that when you went to the store that one day, there was that person without the mask up front.
Yeah, it was an interesting situation. There is a grocery store that has an employee who is a frontline cashier and bagger and who does not wear a mask. And I was kind of surprised to see it. I had an opportunity to speak with the manager who told me that, well, the individual needs an accommodation. So I think that particularly in counties like Orange County or Ventura County without a mask order, the businesses often can be, the managers can be confused about what they have to do or should do or can't do with regard to something as simple as, with regard to something like an accommodation for someone who can't wear a mask for whatever reason. That type of accommodation, it doesn't mean that you need to put the public health at risk. But it just brings in so many different questions with the pandemic because of the controversy that sometimes arises with regard to mask use, and the position that the employees themselves can be in if they bring this up. But yeah, so a business owner or a manager in that situation or an employee in that situation just really, they need to take a step back maybe and think about what's the underlying purpose here. It's to help accommodate reasonably the employee who needs an accommodation without putting the public health and safety at risk.
I'm gonna, there are so many good questions to which it sounds like, it's hard to know what the perfect answer is. And I guess people can only do the best that they can. And I know that people are going to have questions afterward. I hope that they will reach out to all the people here for, whatever did not get answered here. And I know there are a number of questions that have been raised that we just won't have the answer to yet. And people just have to do the best they can. But I wanted to also ask you, and I know that Hillary and Jeff, you had mentioned even that, there's going to be different county requirements and how do employers respond to those. But I noticed also in what you're commenting on issues with respect to whether employees want to come back to work or whether people, whether it makes sense to bring certain people back to work. I wanted to connect that to Steve, the issue under PPP, where also you need to be thinking about the full-time employee or equivalence computation. So are we also, are there pressures for the business owner where they're going to have to look and consider, how they're dealing with their employees, but also, consider how that impacts possibly, the issue of forgiveness. Steve, we can't hear you. I don't know why.
Now?
Yes, we can.
The only pressure on the employer is not to be the employer that permits a sick worker displaying symptoms to come into the workplace and infect others.
That's true. That's the most apt
calculation of FTE, be damned.
That's true. I didn't mean to make an equivalency of them.
I know you did.
Thinking more things for people to consider.
You're going to be dinged on your FTE if you properly ask a sick employee to leave. And in a sense, you've reduced your workforce. Well, as long as you pay them, no, you won't be dinged.
Or if there's, I guess if you can establish.
Don't fire them because they have COVID-19 disease.
No, and
unless Hillary and Jeff tell me it's okay.
Right, that raises more employment.
No, I mean, I was just going to say, if an employee comes in and the employer says, it appears you're sick and sends them home, then there are reporting time requirements for reporting time pay in California too. So that employee is not necessarily going to be unpaid if they're sent home.
There could be an issue there if the person repeatedly, I'm better now, and keeps coming in and they know they're sick, stuff like that. Which brings me to a couple of the points, and I know that we may have questions afterwards for those who have time to stay, because I think we've gone over our hour, which is great. It's one, privacy laws. State law does say you have to keep, for example, with your employment file, your employee file, and their medical records separate. You know, for example, if you had a sexual harassment complaint, it's on a need-to-know basis. The owner of a company should not be going around saying, hey, to everybody, hey, such and such has COVID-19 and things like that. That is a medical privacy matter, and California has clear laws on that. If it's a matter of they need to be sent home, there's a few people. It's a Speedback says, are we going to 4:45?
You know, we had anticipated an hour, but I noticed in the materials said an hour and a half. So
okay, great. We're going for an hour and a half. So we have
allowing
time.
us to.
I'm sorry, you guys. I thought it was an hour.
It's
So I think the issue, Jeff. So feel free to elucidate. It says Mr. Spiewak says we're supposed to get 1.7.
I'm aware of an hour and a half. So but go ahead.
I don't know about that, Mr. Spiewak, but we will talk to them, because if it's an hour and a half, then you should get credit for it. Okay, so going back to this issue, there are clear privacy laws, and I know that Jeff and I talked about this. You cannot give out just any information about any employee. It's things like that. So if a person has COVID-19, if a person's going through a divorce, if a person has things like that, those are not things that should be discussed around the office. That can make them feel embarrassed, uncomfortable, and depending on the nature of their work, things like that should not be disclosed. Sometimes if there's a friend in the workforce and things like that, but personal issues and privacy issues like that, say for example, a person's a victim of domestic violence, that does trigger other responsibilities of the employer. And so there are other considerations here. So it is not a good idea. I would recommend saying is such and such is going to be out for a few days. You're going to discuss it? No, you cannot. Or you can discuss that if there are privacy matters here. But I think you have to really guard a person's privacy on this, because we've all seen how this happens, particularly in a COVID situation. That's going to spread like wildfire around the office if someone has COVID-19, particularly right now. And I think if you have someone out gossiping about another person, you are, one, breaching their privacy, which could give rise to a cause of action. You have the additional problem that you've got a hostile work environment. So someone comes back and said, hey, I had no idea. Why did you tell everybody? We've all seen this. This is like the junior high or high school or college thing where, hey, I come back and you told everybody everybody knows now. So that happening in the workplace, depending on what it is, could give rise to a hostile work environment complaint. Or the person may quit and you may have a constructive discharge issue, because the person says, well, I quit, but you made it so difficult for me that I didn't feel comfortable coming into the office. It's sort of like having the boss that yells at you and gets in your face every day, and the person quits to go, well, you left, and they're like, well, what am I going to do here? So I think people really have to be sensitive to these things. I think you are probably, given what they've discussed about mental health issues online, people often, we get a lot of these, we handle a lot of definition too. People are posting, they're posting how they feel about their boss, they're posting how they feel about work, they may be posting how they feel about a colleague or current events. As an employer, it's okay, Mr. Spiewak, don't worry about it. I didn't know that either. But I think as an employer, it's good practice to be aware of what people are doing. It doesn't mean to stalk them. It doesn't mean every week. But if you have somebody, some people cannot stay off their phones. I mean, they can't. They are on their phones till they go to bed. They're tweeting. They're whatever they're doing. You need to make sure they're not discussing other persons in the workplace, things like that. They have the right to comment upon workplace conditions. It is a much different thing to be calling names to your boss or your colleagues. You go, oh my God, she looked horrible today. And, things like that are really going into a different area where you're talking about bullying, depending on a person's gender, race, or sexual identity. You may have other claims there. That is how that stuff starts. So it is always the better practice, and I think that Jeff would agree, for an employer to at least have some awareness of it. It is not going to be in a defense in any kind of civil action when they get a hold of a plaintiff's attorney who's eager to make a few bucks and figures it's cheaper to settle than litigate, and has that person over there and say, well, I had no idea what's going on. And it's like, well, it's your job and responsibility. And the current state of the law is they have a duty to notice things like that. So things like changes in behavior, again, it's harder to do when you're working remotely sometimes, but sometimes it isn't. Maybe you have someone who's in regular contact with you, for example. You haven't heard from them as much. Maybe you have a Zoom meeting and they're not talking much. Maybe you just to check in with that person. But you should absolutely be doing these things. And if you're not, and again, I think Jeff is right, given the panic and other issues that came up with COVID-19, which is understandable. The financial, the obvious risk to your health, this has never happened before. What do I do? Do we have to close down? And can I get funding? And all those very important questions. You may just have so much on your plate that it falls off your plate for a bit. But when it falls off your plate or you forget about it, that's when it's going to become a problem, because it leaves the door open for something like that to happen. And in the best case scenario, it doesn't. You hope you have a friendly workplace where people feel comfortable, either at a minimum telling you if there's a problem. But if there isn't a problem and no one tells you, that's when you're going to get a demand letter from a plaintiff's attorney saying, hey, this happened and I'm very uncomfortable.
Yeah, and on those issues in California, if it comes to a claim of discrimination or retaliation, those can only be brought against the employer entity. But if it comes to harassment, then all of a sudden there can be individual liability as well. So the managers themselves don't want to be on the wrong side of the V in that kind of harassment scenario. Another area of law related to this sort of privacy concerns is the California Consumers Privacy Act, the Ccpa, which there's been a lot of discussion about, but maybe not so much lately with COVID-19 going on. This is a law that, as it relates to employees or job applicants, it doesn't really go into effect until January 1 of 2021, except for two requirements, two categories. One, reasonable security measures to safeguard data that's collected, and two, disclosure of the categories of personal information collected about employees and job applicants, and the business purpose for which that information is used. So to the extent that during reopening, an employer decides that they're going to implement some kind of screening or questionnaire, whatever it might be, don't lose sight of the CCPA requirements and disclosures that could come back to haunt you if you just forget about them.
And Jeff, how do you feel about background checks? Because I'm getting a lot more calls lately. What can I do and what can I do?
Well, do you mean background checks with regard to just personal background, financial background, or?
Where there would be, if you have a job applicant and you're just considering making an offer. You like them, but you've been burned before, for example. That's the typical thing to hear. And yeah. I want to check further into this person's background.
Yeah, no, that's absolutely required, but it's very tightly regulated by law, and this is also an area where local laws might come into play. So, for example, typically an employer will want to have a third party probably help with some of the paperwork to make sure that you get the proper consents and authorizations from the job applicant. But then if you want to take your background check into criminal background, all of a sudden you have the so-called ban the box laws, which really limit the extent to which an employer can consider a criminal background before making a decision whether or not to offer a job. So you have to very carefully do this step by step. You have to follow all of the requirements in California and federal law with regard to background checks in general and for job applicants, and then make sure that what you're doing aligns with any requirements as to ban the box issues. And as it relates to the COVID-19 pandemic, everyone is going to be particularly cautious, I imagine. You certainly want to make sure that you're doing all of these background checks and anything else in a manner that doesn't inadvertently or through oversight violate privacy or collect information that you're not supposed to be making input.
I think LaVonne has a question.
I'm trying to.
LaVonne's got a question here.
I think we're winding down, I think, into our last 30 seconds. I see, though, that Steve has a hand up. Find out what he wants, and then I'll give everybody their last 30-second comment before we sign off.
If I have a 30-second comment left, I would say that this is one of the busiest times I have ever been engaged in terms of the needs of business clients, the volume of materials that have come out, the uncertainty over so many things, not just in terms of loans, but also so much to do with employment issues. And it's also, in decades of experience, the most collegial and interactive I have ever had the opportunity to be with colleagues, with business consultants, accountants, and other attorneys. I really feel it's a period where everyone is pulled together to try to get the best possible answers at the moment in time the question is asked. So thank you.
I can relate to that, absolutely. What are what are your last, if you want to make sure, because there's so much here, and I wish that we had calibrated more time for this, because everything that you all are pointing out is just so important. And I hope that people follow up with each of you, because there's, I know that there's going to be more questions. But, what's the last thing, though, kind of signing off as we going to wind down in a few more minutes? What's something that you would want to, just let people know as we're, make sure that you'd let people know before we end this particular program? Okay, Steve, so start. Go ahead.
Go back over your documents, your internal records. It's boring. It's painful. There's no joy in it. To do it, my closing line would be prepared, and you will be safe.
Very good advice. Advice from Jeff.
Don't panic. It's always better to confer with counsel if you have a question before making a decision in the spur of the moment that might have unanticipated consequences down the line. This is a complicated area. The law is developing in many cases. Don't lose sight of the fundamentals and just keep doing the good job that you're doing.
Wonderful. Advice from Hillary.
Yeah, Jeff took my don't panic, but that's okay. And Steve is so good. I got to follow both of them. So I priority, make safety and your health a priority. You need to do that. It's not going to help you if you're dead. I mean, it really isn't, or anybody else. And I think there are a lot of resources out there that are online or we're all members of the Chamber of Commerce and the Bar Association, so we're fortunate. We probably have a lot of resources available. But there are ones online too that are really helpful to a lot of people. I mean, I wouldn't believe everything you read, but I think it's fairly reliable. If you read, an article written by a lawyer, you probably assume I'll assume most of them are true. And but I also think about the fundamentals, like Jeff says. Insurance, look at your policies. You might have coverage, business interruption insurance. They are rewriting a lot of these policies right now because of COVID-19. If you can extend your current policies out, look into it. And the good old-fashioned torts like defamation and things like that on social media and anywhere else, those are all still applicable. And again, we get a lot of those because such and such posted this about me. So, I mean, I think instead of watch your P's and Q's, it's watch your tweets and posts. I mean, you really have to make sure that you're not doing those things. And I know that I'm sure Jeff and Steve and LaVonne, I'm sure even too, have all had, I'm like, you posted what, or you did what, I really wish you'd asked me first before you, well, I was upset, so you don't want to be in that situation. But I think primarily you got to stay safe and you got to stay healthy. I mean, that's safe. Those have got to be your number one priority.
That is for sure. Those are all great points that you've each noted, and it's good advice and well taken. I want to thank each of you. Thank you to each of our panelists, to Steve, to Jeff, to Hillary, and to Larry, who had to leave a little bit early today. Thank you to the Beverly Hills Bar Association, the Beverly Hills Chamber of Commerce, and particularly to our attendees and participants. Again, the materials do have contact information for our panelists. If you have questions, do not hesitate to reach out. This was wonderful, you all, and thank you again, and I hope you all have a great rest.
And thank you for moderating, LaVonne.
Thank you.
And thank you.